Yes, Mr. Rowe, we do wonder why you're here.
Well, I shall endeavour to explain.
Yes, well, we thought we'd let you. We thought you'd let you try.
But I'm grateful for that early indication of the query that is crossing your ladyship's mind. I noticed the timetable gives me from 10:30 until 12:40. I don't propose to take all of that time.
We're relieved to hear that.
Unless the board perhaps is in a especially interrogative mode, but I suspect that
Are you telling me to shut up, Mr. Rowe?
I shall
probably telling me to shut up.
I shall certainly.
No, we do not think that even were we to continue to hear you, which we're going to do, of course, the case needs to last beyond the short adjournment.
Well, I'm
grateful. Mr. Ramlogan would probably accept that.
My lady, as you'll have gathered, I appear for the appellant while my learned friend Mr. Ramlogan, senior counsel, appears together with Mr. Tom Richards and Ms. Chelsea Stewart for the respondent. I'll call the appellant the Commissioner and the respondent Mr. Singh. There is indeed the preliminary question, I suppose, as to whether we should be here at all. It's said in the respondent's case that we don't challenge the Court of Appeal's orders, only its reasoning. And that's simply not right. Our case makes clear what we invite the board to do is to reverse the decision of the Court of Appeal, to set aside the decision of the Court of Appeal and to substitute a decision and to substitute a decision dismissing the claim. So there's nothing academic about the appeal. It's true, of course, that the practical effect of the very rapidly obtained injunction that the Court of Appeal granted way back now in 2008 is that Mr. Singh was in practice able to sit the assessment, and so to that extent the practical aspect of the case has been dealt with. But that doesn't mean that the issues that arise on this appeal, and indeed that arose in the Court of Appeal when the matter got to the Court of Appeal substantively, are not still relevant. We contend that they are. The facts are, of course, as the board will have gathered, extremely simple, and we can really pick them up, perhaps unusually for an appeal to the board, from essentially one piece of paper, and that's the piece of paper at page 133. At any rate, we can pick up the story at that page. Page 133, volume 1, for those who are using the paper copy, is the memorandum to the Commissioner from Mr. Singh on the 10th of November 2008. This is about a week after, I think it was the 3rd of November, in fact, Mr. Singh had been first given a letter saying that he was to sit the assessment for promotion, and then on the same day told that after all he was not to sit the assessment for promotion because he was not eligible to sit it. And this is Mr. Singh writing to the Commissioner on the 10th of November. He says that he's been acting, and accurately says he's been acting in the rank of Superintendent of Police with effect from the 19th of November 2007 and was confirmed in this rank on the 3rd of March 2008. And I'll show the board later the statutory material which gives effect to that process of, first of all, acting in a rank and then being confirmed in that rank. I've completed 11 months and 24 days in substantive rank as at November 13, 2008. That's important because it's agreed that there is a 2-year probation period. So at this point he is a probationary or probationer superintendent of police. He refers to his performance appraisal, which he says is to be prepared and forwarded to you 1 month before the probation period expires, which is the 19th of November 2008. Moreover, there is no barrier preventing me from taking the required assessment examination. In the circumstances, I respectfully seek your leave and permission to pursue the examination in accordance with the regulations. And I was perhaps exaggerating when I said it was only one piece of paper. I think it's two we need to look at because we need to look at the response, which is at page 137 from the Office of the Commissioner, November the 12th. Acknowledges receipt of that memorandum we've just looked at and says, I am to further advise that the stipulated probationary period alluded to in Regulation 21 of the Police Service Regulations is 12 months. I think I said 2 years before 12 months, when constituted the period during which you acted prior to your confirmation in the rank of superintendent, and that since your confirmation did not satisfy the requirement of the probationary period, Consequently, you have not qualified for the first division assessment, and as such, I cannot accede to your request. And that, in short, encompasses essentially the dispute between the parties as of that stage. That highlights, of course, the area of debate in the case. Putting it initially, if I may, in perhaps rather general terms, we are concerned with the position vis-à-vis sitting an assessment for promotion of an officer who is still only a probationer in the rank from which he or she aspires to be promoted. I need, of course, to deal, because this is emphasised in the respondent's case, in Mr. Singh's case, with the question of policy versus the statutory interpretation. In other words, are we talking here about the lawfulness of a policy that only persons who have completed their probationary period may sit the assessment to move to the next rank up? Or are we concerned with something else? The statement of facts and issues, it's fair to record, does put it, certainly as regards the Commissioner's position, in those terms, and talks about the Commissioner's policy that only after you have served your probationary period in full may you put yourself forward for promotion to the next rank. But as your Lordship will have seen from the Commissioner's printed case, on reflection, it's probably not quite right to speak in terms of a policy, for the reason which is pointed out in Mr. Singh's case, which is that there does not exist a distinct document or set of ideas undocumented as such constituting a distinct policy.
Well, it is the case, in this case at least, that the Commissioner took the view that Mr. Singh was ineligible.
Yes, I accept that.
That has got a problem, and therefore, if he took the view that he was ineligible, his policy can only have been, we won't let people who are ineligible sit.
Well, I agree, he took the view that there was an ineligibility on Mr. Singh's part to proceed. What we're really concerned with, in my submission, is really the correctness or otherwise of the Commissioner's reading of the scheme. And that involves something which is perhaps not properly on reflection described as policy, but it does involve a question of a reading of the scheme. And as we shall see, and I'll seek to demonstrate, the scheme contains quite detailed provision in relation to some aspects of the questions of promotion and service and so forth, but is not specific in relation to the particular question that we are concerned with. But
I'm sorry, Mr. Ray,
yes.
I thought that the Commissioner's concern was the decision in the Court of Appeal saying that people in Mr. Singh's position have a right to sit the exam.
Well, your Lordship anticipated my very next sentence.
Oh, I'm sorry.
That is not at all. But no, that is a particular concern of the Commissioner, is that the Court of Appeal said, as your Lordship says, that there is a right on the part of somebody in Mr. Singh's position. She is entitled to sit the assessment for promotion.
Mr. Ray, I certainly had thought that you were putting forward a policy argument. Now you seem to be shifting slightly from that, and you say, well, we've got to look at the scheme. By the scheme, I suppose you mean the regulations. If so, you're not taking a policy point. We're back to the legal point, aren't we?
Well, the reason I perhaps on reflection shy away from the word policy is the point that my learned friends make, which is that you can't pull up a distinct document which says this is our policy as to how we apply the statutory. When I say the scheme, I do mean yes, my Lord, the Act, the Constitution, the Act, and the regulations. What I really say about that is that where the statutory scheme is not explicit, its provision about in its provision about particular issues, it is, at least in the first instance, for the Commissioner to adopt a reading of what the scheme as a whole requires, and that this is the reason why the term policy is not perhaps quite apposite. It is a question of the Commissioner's interpretation. I do say the Commissioner is entitled to adopt an interpretation of the scheme, and that provided that is an interpretation, my primary point would be provided that is an interpretation of the scheme which is a reasonable one, then it's one the Commissioner is entitled to adopt and to follow. But in any event, because I can see it might be said against me in relation to that, well, hang on, isn't it a matter for the court? In any event, I do say that interpretation of the scheme is correct, so that we are concerned, the Commissioner is correct, even if one is concerned simply with a pure question of statutory interpretation.
So you are actually arguing that a person in Mr. Singh's position was ineligible, because that's the view that the Commissioner took. I thought you weren't arguing that.
The Commissioner took the view that under the terms of the scheme, a person in Mr. Singh's position is ineligible. I say that insofar as there is room for the Commissioner to take a view about what the scheme requires, he was entitled to take that view. But if it is said against me, well, he's not entitled to take a view, it's a matter of black letter law, either the scheme provides for one thing or it provides for another, then his reading of it is a correct reading.
But there are three possibilities, aren't there? One is the Commissioner was initially right that probationers are ineligible. That has an instant counter to it. Another possibility is that the Court of Appeal was right to say that probationers, if they've got the right number of points, are entitled.
Yes.
But there is an intermediate position that they're neither ineligible nor entitled, and it's a matter for the management of the police service, which is generally in the hands of the Commissioner, what his practice is in relation to letting probationers take the exam.
Yes. And my lady,
I would have thought you were arguing for the middle course, weren't you?
That is, yes, it certainly is. I mean, I will seek to show by reference to the material in the statutory scheme why the reading of ineligibility is right, but it may not matter whether I'm right about that. If I get home on the proposition that on your Ladyship's third proposition, that there is an in-between position, which is that, as your Ladyship puts it, it's a matter for the management of the service.
The statute could be a complete, the scheme could be a complete code. That is
yes,
obviously a possibility.
Yes, but it's certainly right to say that and it's a perfectly fair observation, that the Commissioner's primary concern is the Court of Appeal's positive assertion that there is a legally enforceable right on the part of anybody who is in a probationary position in any rank of the First Division to sit the examination or the assessment for further promotion, even before the probation has come to its end, successful or otherwise. Can I, with that?
Mr. Rowe, but you did sign up to the statement of facts and issues, and you were clearly putting it on the basis that your client was entitled to maintain a policy. Well, there it is.
Yes. Well,
let's proceed.
Your Lordship highlights a distinction between the way it's put in the Statement of Facts and Issues and the way in which the case puts it. But I seek to put it today in the way that I've endeavoured to explain. Maybe I can take the board next to the statutory material, which is fairly slight, but does bear a little bit of looking at. This is all starting at page 916, if one is on the computer, or in, I think, a separate bundle of authorities, if not. And we start, if we may, briefly with the constitutional provisions. This is all in Chapter 9 of the Constitution, appointments to and tenure of offices. And may we pick it up at page 920, which takes us to section 122 of the Constitution. That establishes the Police Service Commission. 123, we needn't deal with the detailed provisions under 122. 123 deals with the powers of the Police Service Commission. They include appointing persons to hold or act in the office of Commissioner and Deputy Commissioner. They can make appointments on promotion or confirm appointments. And so on and so forth. They have to prepare an annual report, and they have to monitor the efficiency and effectiveness of the discharge of their functions, and so on and so forth. They can hear appeals. And then skipping to the most directly relevant provisions, we come to page 923, which has on it section 123, capital A of the Constitution, subject to section 123(1. The Commissioner of Police shall have the complete power to manage the police service, and he is required to ensure that the human, financial and material resources available to the service are used in an efficient and effective manner. It's subject to section 123(1) because, of course, if one turns back, one can see that the Police Service Commission can do some things which would necessarily involve overriding the judgment of the Commissioner as to how to manage the police service. But as far as the specific provisions that we're concerned with in this appeal are concerned, Section 123A, subsection 2, the Commissioner of Police shall have the power to A, appoint persons to hold or act in an office in the police service other than an officer referred to in Section 1231A, that's other than the Commissioner himself or herself or the Deputy, including the power to make appointments on promotion and to confirm appointments. B is about transferring police officers. C is about discipline. Subsection 3 allows delegation. Subsection 4 is important. In the performance of his functions under this section, the Commissioner of Police shall act in accordance with the Police Service Act and the regulations made thereunder. That makes it necessary to look at the Police Service Act. That starts at page 925. Substantively, it starts at page 931. It's described as an act to consolidate, amend and revise the law relating to the police service, so as to ensure efficient and transparent management of the service and to provide the principles of equity and meritocracy shall be applied at all times and for other related matters. And then can we, within that, my lady, go to page 937, which is appointment and promotion of police officers. Section 16, in the exercise of the powers vested in him by Section 123, capital A2A of the Constitution. That was the provision of the Constitution that gave the Commissioner power to appoint persons to hold or act in an office in the police service. The Commissioner shall take into account, in the case of promotion to and within the First Division, and we're concerned in this case with the First Division, the results of the promotional assessment process, or in the case of the Second Division, some recommendations from the Promotion Advisory Board when he makes an appointment on promotion. Subsection 2 is, as it were, an exclusionary provision. A police officer shall not be considered for promotion to and within the First Division unless he has attained the prescribed points. The Commissioner shall ensure that the points attained by the officer are sent to the person mentioned in Section 17A1 prior to the commencement of the promotional assessment process. We'll come to that in a second. Subject to 16.2, this is Section 17, promotions to and within the First Division shall be made by the Commissioner only on the basis of the results of a promotional assessment process. And then 17A, where there is a vacancy in the First Division, the Commissioner shall, in accordance with the procedure prescribed, cause to be contracted from time to time a person to design and implement a promotional assessment process in accordance with internationally accepted promotional assessment standards to determine the suitability of promotion of a police officer to and within the First Division. The person, i.e. the person so contracted, as I read it, shall conduct the promotional assessment process to determine the suitability of promotion to and within the First Division to the next higher rank of a police officer from the rank of inspector through to senior superintendent, and shall submit its results taking into account points obtained by the officer under Section 16.2, that is to say, the prescribed points, in the form of an order of merit list to the Commissioner in relation to his functions under that section in the Constitution. Subject to Section 16.2 to be eligible from the promotion, there's subsection 4 I'm looking at, subject to Section 16.2 to be eligible for promotion to the rank of Assistant Superintendent through to Assistant Commissioner. An officer from the rank of Inspector through to the Senior Superintendent shall be subject to the promotional assessment process by the person. Subsection 5 requires the criteria and procedure prescribed to be taken into account. And then we can break off at that point, if we may, because the next section is about the Second Division and the Promotion Advisory Board. The next relevant provisions, I think, are at Section 21 over the page at page 940. This, and we're still, of course, in the Act here, but this deals with the question of probation. A police officer on first appointment shall serve the prescribed period of probation. If at any time before the end of the probationary period of a constable, the Commissioner has reasonable grounds to believe that the interests of the police service will not be served by retaining the constable, the Commissioner may dismiss him in accordance with the procedure prescribed. A constable who successfully completes his period of probation, who satisfies all the prescribed requirements, is eligible to be confirmed as a constable. And then more generally, not just to constables but to all officers, a police officer who is promoted shall serve the prescribed period of probation. So that deals, I think, with the relevant provisions of the Act. One then needs to go to the police service regulations. They start at 941, my lady. Again, substantively, we can pick it up at 950. Part 2, probation and promotion. Regulations 11 and 12 concern first appointment of persons as police constables, 2-year probationary period at that stage. 12 tells you how you have to treat a police constable who's on probation. And then at Regulation 16, there's a provision about qualifying examinations. This applies to an officer of the rank of constable through to sergeant, so here we're in the 2nd division. But such an officer may apply on the prescribed form to the Commissioner to be allowed to take the qualifying examination for promotion to the next rank. An officer who is successful in the qualifying examination may be considered promotion in accordance with Regulation 20, which is the provision about, we haven't got to it yet, but it's a provision about promotion within the 2nd division. That appears to be, I observe, the only provision in the regulations that seems explicitly to say that anybody has any sort of entitlement to apply for promotion. An officer of the rank of constable through sergeant may apply.
To be allowed?
To be allowed, yes. It's not an entitlement to be, it's not an entitlement to be allowed to, it's not an entitlement to be promoted, certainly. It's not actually even an entitlement expressly to be allowed to take the exam. It's an entitlement to apply to be allowed to take it, as your Lordship points out.
Presumably there would be an implied obligation on the Commissioner to consider whether in exercise of his discretion to allow.
That must be right, my Lord, yes. Then we have 18 is about advertisement of vacancies. Then 19, side note, principles of selection for promotion to and within the 1st division. The Commissioner shall publish a departmental order specifying the point system to be followed by a supervising officer in the preparation of a performance appraisal report. I don't think, and I'll be corrected if I'm wrong, though I've discussed this with my learned friends earlier, and I don't think I'll be corrected on this, that I don't think that actually that departmental order is in the material that has been before the courts in this matter. But it may not matter because the fact is that it requires the specification of a points system. We can see something which is perhaps akin to it if one goes in the record to page 45, volume 1, page 45. That's, yes, page 45, volume 1. This is a departmental order establishing the Promotion Advisory Board, which, of course, what you'll recall was the provision to do with, was the entity that is relevant for promotion in the 2nd division. So it doesn't take us much further forward, but it tells us at least what sort of thing a departmental order is.
It might be worth noting that Regulation 17 is another, you shall not be considered for promotion unless. It's spelled out there.
Melly, that's very true, yes.
But there isn't an equivalent for the for the 1st division.
No, there isn't exactly. There isn't an equivalent explicit, one might say, hard provision, like Regulation 17 that your Lordship points out, which applies other than to constables. But I agree, as far as the constable is concerned, it's black and white. You simply can't be considered promotion until you've had 3 years in the service. I was just taking your Ladyship to page 45, which is the Promotion Advisory Board, but we can see that the sort of scheme of this departmental order, the board is is referred to on the first page, and there are provisions about who it has to comprise and so on and so forth. Over the page we can see methodology for promotion in the second division. And there are criteria about how you allocate points, how many points you get for your interview, how many for your examination, and so on and so forth. So although it doesn't appear to be in evidence, it is, one assumes, to be inferred that there exists something similar as regards the first division. Now, I was at Regulation 19, page 951. The Commissioner has to publish a departmental order specifying the point system to be followed by a supervising officer in the preparation of a performance appraisal report. The points awarded to a police officer based on his performance appraisal report shall represent 25%, and the results of the promotional assessment process shall represent 75% of his final grade as stated in the order of merit list mentioned in sub-regulation 9. We'll get to that in a bit. Over the page at 952, a police officer shall not be considered for promotion to and within the first division unless he has attained 60 or more points on his performance appraisal report. And this assumes some importance in the decision of the Court of Appeal. It's another prohibitive provision. It shuts you out of the process as a police officer unless you comply with some condition. But again, it doesn't explicitly say what it is you need to have in order to be within the condition of eligibility, or indeed what the rule should be as regards who is regarded as eligible, who is treated as eligible by the Commissioner. 4 sets out how the process is to be conducted. There's a panel, who needs to be on the panel, and so on and so forth. And then 5, and this also was featured in the Court of Appeal's reasoning, as we shall see in a bit. The promotional assessment process shall comprise of 2 stages as follows. Stage 1 shall require every qualifying officer to write a qualifying examination from which only the top performing candidates, as determined by the person, that's the person contracted to do all of this, shall proceed to stage 2, and stage 2 shall be a suitability assessment process. Qualifying officer, I submit, is used almost in passing there as a reference back implicitly to subsection 3, somebody who is at least entitled to be considered for promotion in the sense that he or she is not barred by subsection 3 as having less than 60 points. But as we'll see in the Court of Appeal's reasoning, it seems to have borne quite a lot more weight as being an indication that provided you get over the hurdle of having 60 or more points, you are then qualified in the sense of entitled to be considered for promotion, even if you are only a probationer in the rank from which you aspire to be promoted. Anyhow, that's subsection 5, or sub-regulation 5. Sub-regulation 6 talks about how this is to be done in terms of the suitability assessment, role play, hypothetical situations, and so on and so forth. 7 is about establishing the competencies and giving them in writing to each qualifying candidate. Again, that phrase, qualifying, at least 1 week before the suitability assessment process is conducted. So all perfectly, as you might imagine, sensible methodology for telling people what it is they need to show those examining that they're good at before they come to the examination. 8 makes provision about what sort of things the competencies ought to be: decision-making, problem-solving, customer relations, and other sorts of things that no doubt it's sensible for police officers to be good at. 9, which was referred to earlier, you'll recall in sub-regulation 2, deals with the order of merit list. Subject to sub-regulation 2, every officer considered for promotion shall be rated according to the results of the promotional assessment process specified in this regulation, together with the points awarded to him based on his performance appraisal report, and be placed on an order of merit list. The person shall, as soon as the promotional assessment process is completed, submit the order of merit list to the Commissioner, who shall immediately cause it to be published in a departmental order, and it's then valid for 12 months. And it can be extended, the validity can be extended under sub-regulation 12. Promoted during the 12-month period or such other period as is ordered by the Commissioner, I'm reading now from 13, is required to repeat the promotional assessment process. So the scheme there essentially provides for this construction of this order of merit, which tells the Commissioner, who is exercising the power to promote people and must exercise it in the light of the process, tells the Commissioner what objectively, insofar as these things can never really be objective, is the order of merit. In other words, who are the best people ranked in order of merit to be considered for promotion. That's all to do with the promotional process, but of course this all arises in the context of this issue of probation, and that's touched on at Regulation 21, which is on page 954. An officer who is promoted to an office, this obviously must be subject to the explicit provision in relation to constables, whose probationary period is different, shall serve a probationary period of 12 months in the office to which he is promoted. Subregulation 2 deals with this notion of acting, which is relevant to the present case because Your Ladyship will recall that Mr. Singh had been an acting superintendent for a while. Where an officer is promoted to an office in which he has performed the duties, whether in an acting or a temporary capacity, for a period of equal or longer duration than the prescribed period of probation immediately preceding the promotion, the officer shall not be required to serve the probationary period. And 3, which is directly relevant, where an officer is promoted to an office in which immediately preceding the promotion he has acted for a period less than 12 months, the period of acting service shall be offset against the prescribed period of probation. So one can be in a situation, as Mr. Singh was for a while, where one is initially just acting as an officer of a particular rank. One is then formally made an officer of that rank, but one is still a probationer. And at the end of the period of 12 months from when one started acting in that rank, one has completed one's probationary period. And at the end of that probationary period, one gets, and we'll see in a moment, a performance appraisal report and then confirmation. I'm just going to skip over 21.4, not because I don't want Your Ladyship to read it, because I don't think I'd get away with that, but because I want to come back to it. Regulation 22. In the case of an officer serving a 12-month period of probation, the senior officer, this is what I was saying about the scheme of things for probation, the senior officer in charge of that officer shall furnish to the Commissioner a performance appraisal report 1 month before the period of probation expires. If, 23, if after consideration of the final report of the senior officer, the Commissioner is satisfied that the officer's probationary service has been satisfactory, he shall be confirmed in his appointment with effect from the date of the appointment. If the Commissioner is not satisfied that the officer's probationary service has been satisfactory, the period of probation may be extended for one further period of 6 months. And then there are provisions about pay in those circumstances, and 26 says that there has to be a record of who's on probation. So the overall scheme, and I'll come back of course to 21.4, but the overall scheme allows for the possibility that there will at any given time be people who, though to the outside world are superintendents or whatever it might be in the police service, in fact, either people who are simply acting as if they were superintendents or whatever it might be, or people who have been given that title but on a probationary basis and who are, in those circumstances, not necessarily going to continue on that basis because they are, by definition, on probation. They are proving whether they have got what it takes to be a successful officer at that rank. And at the end of their probationary period, or 11 months after they began their probationary period, they are given a performance appraisal report, and they're then given a final report, and it depends upon whether the Commissioner is satisfied that they have satisfactorily served out their probationary period, whether or not they in fact become non-probationary officers in that particular rank.
What happens at the end of the 6-month extension of the probation?
Well, implicitly,
it doesn't. The Commissioner is still not satisfied that the performance.
Well, it doesn't say expressly, but implicitly, my lady, it must be that having failed to prove that you are adequate for the role, you cease to be occupying that role.
So you revert to your previous one, or
presumably.
or what?
Yes, I presume that must be right. There's explicit provision for what happens if you're a constable who doesn't succeed as a probationer. That's going back to 11 and 12 and 13, because there's provision to dismiss a constable. I don't think it expressly says what happens if you just get to the end of the probationary period and you're found wanting. But implicitly, it must be that it's inherent in the nature of probation that nobody's committed to taking you on until you've successfully completed your probationary period. And likewise, it must be implicit in the nature of probation in any other rank in the First Division that if you fail to prove your fitness, your in the terms that are used here, the satisfactoriness of your service, then that you haven't proved yourself, and therefore you're not confirmed in that rank. That must logically be what happens.
That's logical, yes.
Can you only go up by increments, or can you leapfrog a rank?
Well, that isn't a question which the regulations themselves
Silent.
Provide for. No, Molly, precisely, they are silent about that. And
if you could leapfrog, then it would suggest that the probationary period in the current role has got no.
Well, that's right. The way that we put it is that the reading of the overall scheme that the Commissioner adopted, which is what feeds into this the way the decision was put of ineligibility, is that the scheme is one under which, at any rate ordinarily and barring some exceptional circumstance, you do progress in an orderly fashion from one rank to a probationary period in the next rank, to confirmation in that rank having successfully completed your probationary period, to a period of service in that new rank, and at that stage to the possibility of being considered for to become a probationer, in fact, in the rank above. That's what one would expect as a rational scheme. It is true, of course, and this is a point that's made against me by my own friends, and I'll obviously have to look at it, that Section 21, Regulation 21.4, contemplates the possibility of promotion before you have completed your period of probation. It doesn't expressly say anything about when that should happen, or what the consideration should be as to how it should happen, but it admits of the possibility, because it says, as your ladyship will see, where an officer is promoted before he has completed the period of probation in his former office, the unserved portion of that period of probation shall be waived, and the officer is deemed to have been confirmed in that appointment.
Mr. Rowe, could you help me?
Yes,
on
right.
one bit that's troubling me? Regulation 19.3, the 60 points eligibility condition,
Yes.
talks about on his performance appraisal report. And Regulation 22 requires a performance appraisal report to be prepared 1 month before the period of probation expires, which, is there any other provision for somebody getting a performance appraisal report otherwise than under Regulation 22?
I don't think there is.
Because if not, then the box within which the problem which we're all concerned arises, and the box within which somebody might be promoted before the end of their period of promotion, of probation, seems to be a sort of 1 month box absolute maximum, but actually it's going to be less even than that, isn't it? Because if the report comes out a month before the end of his probation, he's then got to sit the exam's got to be considered and pondered about, and an order of merit produced, and only after all that happens is there a question of promotion.
Well, the performance appraisal report performed its primary function would appear to be under the scheme of the regulations, would appear to be the confirmation of probationers in their appointment.
Yes.
If one looks at the provisions at page 954, 22, as your Lordship points out, requires the furnishing of a performance appraisal report 1 month before the period of probation expires. And implicitly,
Yeah.
23 seems to be referring to the senior officer looking at that report. Well, considering that report, no doubt other things might be taken into account as well, I suppose, if they weren't picked up by the report, but the senior officer knew about other aspects of the officer's probationary service, then he shall be confirmed in that appointment. And if not, then it's extended and so on and so forth. But
there's no other provision for a performance appraisal. It's not a sort of ongoing process of which the Regulation 22 report is just one example, as I understand it. That is the performance appraisal report.
Well, I believe that to be the case.
Yeah.
I mean, it's so far as I read the scheme, that appears to be right. But it doesn't follow from that there's any, I would submit, that there's any entitlement on the part of, it doesn't assist the proposition that there is an entitlement to be promoted or to be considered for promotion, even while one is a probationer, because
I do slightly wonder whether the performance appraisal report only ever applies at the end of your probation, because you might have someone in post for many years.
Yes, I
is
see
there
your
not
point.
some general process of performance of
it does,
appraisal?
well, it does.
Well, this comes back to this whole question about how much is left to the Commissioner as the person in overall charge of the management of the police service to behave like any sensible manager would do, which is obviously to arrange for regular appraisals of the people under his command for ordinary personnel purposes. It would be extraordinary if it weren't possible for him to do that.
Yes, well,
But it doesn't
must be
have the
right.
sort of statutory function which that one does in relation to confirmation or lack of it of probationary service.
No, but I mean, the board, I hope, has our my submission on this, which I set it out in the printed case. But what I've described as the steady progression reading of the scheme is, as I say, one under which one progresses from one rank to the next rank and so on, going through the relevant probationary periods. Perhaps I can just ask your Lordship to look at how we put it in the case. This is really picking it up at page 901, paragraph 17. Probably paragraph 16, which is targeted really at the Court of Appeal. I'll come on in a minute to look at the Court of Appeal, but targeted at the Court of Appeal's positive declaration that there is, or positive assertion in their judgment, and as part of the grounds of their judgment, that there is an entitlement to be promoted. I say at 16, this being so, that is to say, the statutory scheme being so, it's necessary to discern from the scheme as a whole whether there is any rule that by implication applies, at least in the ordinary case, to determine when an officer may put himself or herself forward for promotion. And I've set out the bits we've already looked at in the regulations, and made the point I think I've already made in my submissions this morning, that there is therefore likely to exist at any given time various people who are to the outside world superintendents but are in fact probationers, and I submit it is certainly a reasonable reading of the scheme, and to the extent that there is, and that's important, to the extent that there is indeed a discretion on the part of the Commissioner, or a requirement on the part of the Commissioner to exercise some judgment as to how the scheme should work. I retreated from the word policy, really, because one can't identify a specific thing in advance saying this is my policy, but the Commissioner has to proceed on an understanding as to how the scheme either is required to work, or to the extent that that doesn't jump out from the scheme, how it ought to be understood to work in the sense of how it ought to be operated in practice. And what I've described as the steady progression reading of the scheme means that at least ordinarily, and I say at least ordinarily because section 21, regulation 21.4 contemplates the unusual possibility. An officer who wants to sit the qualifying examination must first have completed the probationary period in the role from which promotion is sought. Otherwise, as I say, you'd have people whose competence to perform one role is as yet undetermined, being considered for promotion to still higher rank. And I say that that's either a reasonable reading of the scheme in the sense that it's one the Commissioner was entitled to adopt, or if it's said to be a sort of black letter question of law, then it's the correct reading of the scheme. It depends upon, I suppose, which of those questions is relevant. Perhaps depends upon the view the board takes as to whose decision ultimately this is, whether it's the Commissioners or courts as a question of black letter law.
Can I just ask another practical question? You
Yeah.
may not know the answer, but it would help if you do. The consideration of the performance appraisal report, for which Regulation 22 requires, is obviously designed to enable the assessment of a probationer in time for his probation either to come to an end or to be extended. Is it conceivable that somebody who got 60 points on his probation, his performance appraisal report, would nonetheless be regarded as not satisfactory for extension under Regulation 23? It's a perfectly neutral question. I don't mean that in a loaded way, one way or the other.
Well, I think the answer, my lord, yes, it is. Yes, it's conceivable, because, I mean, take for example an instance where something has occurred after the performance, after the steps which fed into the performance appraisal report had all taken place. Suppose an officer spends 11 months being a model member of the police service, gets a splendid performance appraisal report, and then on the first day of the 12th month gets drunk and beats a suspect up, or something appalling like that. Not that I'm suggesting that would happen, but under the terms of the scheme, it doesn't appear that the Commissioner is bound to say, well, if a performance appraisal report is satisfactory in the earlier 60-point sense, or in any other sense, therefore the therefore the period of probation comes to an end and the officer is confirmed. 23 talks about consideration of the final report of the senior officer.
I can't help feeling that there is a system of performance appraisals going on in the background.
Yes,
and that it's probably quite a specific regime as to how you score points and what the grading is. I don't know what
There's Section 71, isn't there, of the of something, which we haven't been given. Thank you, of the regulations, Regulation 71.
yes, it is, and you haven't been given it. Perhaps we ought to.
Because it must mean that you need to score your points on your last appraisal report, mustn't it? And for the probationer, Lord Briggs's point is about the practicality of it. He can't get one until 1 month before, and then he's got lots of things to do before he could be promoted.
Yes.
So actually, this is a tiny number of people, potentially.
And if 60 points, I don't know whether 60 points is a high or a low threshold within the pointing system, but if, as one suspects, it might be quite a high one, the concept that somebody could, A, not come to the end of his probation having got 60 points, may, apart from your obvious possible example, be such an unlikely one that, in a sense, the contemplation of this is that he's not going to be promoted until he's done his year, albeit that he can start off the process of seeking to be promoted by sitting the exam. If he's unlucky enough that the annual exam, if it is an annual process, happens to fall within that month.
One can see that point, but it doesn't follow from any of that there ought to be. It certainly doesn't follow that there ought to be regarded to be an entitlement on the part of anybody to put him or herself forward for promotion, and it doesn't follow that the Commissioner, taking the view that the Commissioner took of how the scheme worked, it was wrong to say in respect of somebody who has not yet completed the 12 months, well, that person is ineligible. Well, I think that deals with all of the statutory material I wanted to take the board to. Can I just take the board briefly to the decisions in the courts below? And there's more material than there needs to be in terms of decisions below, because the case took a diversion back to the Court of Appeal and then back to the High Court in relation to what turns out to be a red herring, which is a claim of discrimination, unlawful discrimination, which doesn't in the end get anywhere. But the judgment at first instance of Madam Justice Charles is at 201 in Volume 1.
But she doesn't really say very much until you get to page 220, don't
Which is exactly where I was about to go, my lady. I agree. It can really be set out. It can be looked at really only as regards those paragraphs beginning at 78. She makes the point, her ladyship makes the point at 78 that Regulation 21.4, which we looked at, which caters for the possibility of promotion, or admits of the possibility of promotion while you're still a probationer in one office to a higher office. She makes the point that can't give a right to be promoted before completion of the period of probation. And she says he must first serve the mandatory period of probation as required by Section 21, or even when he was promoted in order for his promotion to be confirmed. She goes on at 80 and 81 to say, in fact, the Regulation 24.1 is ultra vires, which is not a contention that I seek to uphold. But then at 82, Regulation 19 sets out the promotion procedure. Regulation 21.1 and Section 21.4 of the Act apply to police officers who are in fact promoted from the particular rank the individual holds and not to some higher rank which the police officer aspires to. Section 21.4, you'll recall, is the provision that says a police officer who is promoted shall serve the prescribed period of promotion, or probation rather. The judge goes on then to say there is thus a sequential procedure by which an individual may be promoted to a higher rank. To do otherwise would be to put the cart before the horse, so to speak. And then she talks about the procedural propriety on the part of the decision maker. To do otherwise would be tantamount to the court stepping into the shoes of the commissioner, insofar as considering the merits of the members of the police service in their promotion process, a task which the court is not qualified to undertake. The court accepts as reasonable the requirement for the claimant and all of the other officers in a similar position to complete the prescribed probationary period in order to be eligible to write the written assessment. She refers to the discretion, rightly I submit, to the considerable discretion that you get if you look at those regulations. Duty bound to apply the primary legislation in the Act and the regulations under the Act. The Court accepts that the general policy adopted by the Commissioner that an officer must complete the prescribed probationary period is clear and objective, and as such is not unfair, irrational, or unreasonable. The defendant was then therefore entitled to correct the mistake of having invited the claimant to sit the examination. Complaint is made in Mr. Singh's printed case about this reference to policy, and this comes back to what I was saying earlier on. I accept there is nothing which independently can be described as a policy in the sense of a separate thing that either is or might be expected to be committed to paper saying this is my policy as to how I do it. But there is room for, in my submission, for a reading by the Commissioner of how this ought to be done that is consistent with the regulations, and what we get when we unpack the statement that is complained about here, the decision letter that's complained about, you are ineligible to sit the examination, is, in my submission, even if it doesn't follow as a matter of interpretation of the regulation, my primary submission is still that it does, but as a matter of implication. But even if that's not right, and you can't spell that out of the regulations, even by implication, nevertheless, when you unpack what is meant by you are ineligible, what it means is the view the Commissioner has taken as to how the scheme ought to operate is such that officers are not to be allowed to sit the examination for promotion to the next rank until they have confirmed that they are that they are successful, that they have satisfactorily completed their promotion in the rank which they're currently at. But that's the way I put it. And if that's a right understanding of how things were done, then in my submission, the judge was quite right to say that that was not unfair, unreasonable, or irrational. It was a lawful way of doing things, in other words. But that's the judge at first instance. There is then the Court of Appeal, and the fullest expression of the Court of Appeal's reasons appears in the supplemental record of proceedings as I've got it. It's page 867 on the computer. It's a little unfortunate that there was quite such a time lag between the hearing of the Court of Appeal, at which the Court of Appeal gave its decision ex tempore, and then the production of these written reasons some 2.5 years later. But there it is. These are the reasons. And again, one can take, perhaps without any disrespect being intended to the Court of Appeal, one can take the same approach of going really to the meat of it, which is to be found from page 878 onwards, or paragraph 21, under the heading of analysis. The Justice of Appeal, writing this is Justice of Appeal Musai, with whom the other two Justices of Appeal agreed without adding anything, says at 21, in the second sentence, in this regard, the respondent, that's the Commissioner, concedes that the appellant, Mr. Singh, would have been entitled to write the qualifying examination if he were, firstly, an officer within the First Division, and who, secondly, had attained 60 or more marks on his performance appraisal report. That appears to record a concession, essentially, that Mr. Singh had a right to sit the examination, provided only that he had obtained the necessary points. And then they go on then to see whether they can infer on the evidence that he must have got the points. That's not, in fact, quite right, and this may perhaps follow from the, I don't know, but from the delay between the argument and the production of these written reasons, because if one looks at the argument, one can see that actually that concession wasn't made. Page 808 in the bundle, volume 2, in the paper version, shows us the exchange, which seems to be relevant to this, so far as I can tell. 808, line 31. Justice of Appeal Jamadar, so basically what you are saying is that this appellant was not a qualified officer. Mrs. Baptiste Mohammed, no. And therefore, since only a qualifying officer can write the qualifying exam, yes, he could not write the exam. That's correct. Those are my submissions. That's the end of the submission. So it doesn't seem on the face of it that it's right at the Court of Appeal to say that there was a concession that he was a qualifying officer. But in any event, the Court of Appeal goes on to set out its own reasoning that doesn't depend upon that concession. So it may not, the whole thing may not turn on that. Qualifying officer is, of course, the terminology that we looked at in the regulations in terms of the requirement to have 60 points in order to, Regulation 19.3, to go forward with the promotional assessment process. It picks up the wording in Regulation 19.5 about Stage 1 requiring every qualifying officer to write a qualifying examination, and perhaps alludes to the wording in 7 about each qualifying candidate being told a week before the assessment what the target is, as it were, what the competencies are that one needs to show that one has. And one can see that the reasoning of the Court of Appeal, this is at page 879 in paragraph 22, is really all concerned with Regulation 19, about a couple of inches up from the bottom of the page on 879. The question therefore arises, says Justice of Appeal Musai, as to who is a qualifying officer for the purpose of writing the qualifying examination. In my view, Regulation 19.3 provides the answer, namely the attainment of 60 or more points on his/her performance appraisal report.
Well, you agree with that?
It erects a hurdle which one has to get over.
Well, you said qualifying officer referred back to.
I agree that qualifying officer is the term used in Regulation 19.3. I don't accept that you can infer from that anybody who has got 60 points or more, even if he or she is only a probationer, is entitled as of right to sit the exam. That's the point. What the Court of Appeal has done is to take a condition precedent to even being considered for sitting the examination and turned it round into something which, if you've got it, not only means there isn't a hurdle, but actually means that you're there and you're entitled to do it.
Are you entitled to do it if you're not a probationer?
I'm sorry?
Are you entitled to take the exam if you're not a probationer?
Well, that question strictly doesn't arise in the present.
No, but it might
appeal.
inform us as to something.
Well, you would. I'm not sure I would go quite as far as to concede that there is an entitlement in law in any circumstances, but plainly, if you had successfully completed your probationary period and had been confirmed and assessed as having been satisfactorily a probation officer, a probationer, and were in situ, it would be rather more difficult for the Commissioner to say in those circumstances, well, I'm not going to allow you to put yourself forward for promotion to a higher office.
Well, there might be pending disciplinary proceedings.
There might be, precisely. But it perhaps touches on, in terms of informing the overall decision, it perhaps touches on the point about management of the process. But certainly, insofar as we are concerned with a scheme or reading of the scheme which says that you've got to have got past probation before you can, at any rate, ordinarily be considered for further promotion, the position I submit is plain that Section 9, the Regulation 19.3 doesn't assist with that, and there is an obvious line between somebody who is a probationer and somebody who is not a probationer. So while I don't quite go as far as to say there's an entitlement once you're a confirmed officer, certainly the two cases are different, and one can see the rationality of drawing a line at the end of probation. So the Court of Appeal, in Justice of Appeal Musai's judgment, then goes on at 23 to consider about whether the appellant had obtained a minimum of 60 marks in the appraisal report, picking up, I think, the point that it wasn't actually directly in evidence as to whether he had or not, but it seems to be concluded, and I can't gainsay this now, that he probably had got his 60 points. And then at 24, we get the real meat of the decision and the point which causes the particular concern to the Commissioner. It is this Court's opinion the Commissioner acted on a flawed interpretation of the Act and the regulations when he denied the appellant the opportunity to write the Regulation 19.5 examination on the basis that he had not served the full 12-month probationary period. And here's the reason why the Commissioner got it wrong. In our opinion, the appellant, having satisfied on the evidence the Regulation 19.3 requirements of being a police officer seeking promotion within the First Division, and one who had a performance assessment for the period as superintendent with 60 points or higher, was a qualified officer for the purposes of Regulation 19.5 and therefore entitled thereunder to write that examination. And that, I submit, is simply a non sequitur. It is an obstacle that one has to get over, but it doesn't follow from having got over that obstacle that one is entitled to write the examination. And essentially, my lady, those are the materials that I wanted the board to look at. And as I say, our submission is that the way in which the Commissioner approached the problem was either one that the Commissioner was entitled to take, or if it's said against me, well, that's not the question, it's a question of simply black letter, what does the scheme provide for? Well, the scheme doesn't expressly provide an answer to this question, but the answer that the Commissioner gave is the answer. As I say, if it's a matter of discretion, then it's a way in which, as a matter of discretion, if the Commissioner had to interpret the scheme, then a degree of leeway is to be afforded to the Commissioner's judgment as to how the scheme should be interpreted. I mean, I accept entirely that doesn't jump out from the material, and it'll no doubt be pointed out, as it is in the case, that what is said by the Commissioner is, well, I took advice about what the scheme required, and the legal requirements of the scheme were such that you had to be confirmed in office. And I accept that the scheme does not expressly say that. But insofar as I need to do so, I say the scheme implicitly says that, because otherwise it wouldn't make much sense as a scheme, subject to the exceptional case under Regulation 21.4. But what is of particular concern to the Commissioner is that it's not right to say, as the Court of Appeal has said, that there is an entitlement, provided only that you've got 60 points, even if you are only a probationer.
If the Court of Appeal had said something like eligible or not ineligible, rather than entitled, I get the impression we might not be here.
I can't speculate, my Lord.
No,
but I see Lordship's point,
I
yes.
asked the question in the sense that I'm looking to see what the essence of your objection is.
Yes.
The objection jumping, if you like, from a conclusion that there isn't a scheme ineligibility, an actual bar or a condition or a hurdle, however you call it, to a conclusion that therefore there's an entitlement.
Yes, well, certainly my primary submission is that Mr. Singh's claim should have been dismissed because the Commissioner was right to say that he was ineligible. But I can see that what's said against that is, well, that doesn't. It might be said. Your Ladyship has my arguments about this, but it might be said, well, that's not a correct reading of the scheme. Well, even if that's so, nevertheless, it doesn't follow from any of that there is an entitlement, and that's a matter which, if the board agrees, the Commissioner would be grateful if the board would make clear in its judgment.
The disposition at 26 doesn't include reference to entitlement, does it? 881?
Let me just turn it up, my Lord. I'm sure your Lordship's right.
No.
The decision to debar was null. So that's a not ineligible declaration, isn't it, Mr.
Well, one has to read what, in construing an order, of course, one has to construe it in context.
Yes, very well.
One has to look at all of the context, and of course I agree in terms of the letters on the page. It doesn't say there in the disposition section that the reason that the decision was null and void and ultra vires and so on is because actually Mr. Singh was entitled to sit the examination. But any reasonable reader of that will want to know what was the Court of Appeal's reason. And the Court of Appeal's reason was in black and white. He was entitled to sit the examination. My Lady, I hope that makes the Commissioner's position clear. I'm reasonably within time.
Sort of, yes.
I'm grateful.
Thank you, Mr. Rowe. Mr. Ramlogan.
My Lady, the issue in this case, in this appeal before the board, is a rather narrow one, as my Lord Briggs sought to define it. And it's really whether an officer in the First Division who has attained the required 60 points under Regulation 19.3 is debarred from sitting the promotion exam for the next higher rank of senior superintendent because he has not yet completed the probationary period of service. I mean, that's the issue. The answer given by the Court of Appeal to that issue was the declaration, which we just looked at, and the declaration was a declaration that the decision made by the Commissioner of Police to debar the appellant from writing the assessment examination for promotion is null and void and ultra vires the Act and regulations. Now, they arrive at that declaratory relief because he was a First Division officer. He had attained the required 60 points on the performance appraisal, and whilst in the reasoning in the penultimate paragraph they do use the word entitled, that did not form part of the formulation of the declaration itself. It may be a matter of semantics as to whether or not one is entitled or whether he's merely eligible, or it may be that there's some practical importance from the standpoint of the commissioner. But maybe either way, we say that this appeal ought to be dismissed on the facts, because the case we had to meet in the courts below was that as a matter of law, the appellant, the respondent, was debarred from sitting that promotion exam. In other words, the law simply did not admit to the possibility of him lawfully sitting that exam. If, as my learned friends agreed in the SFI, it's a question of whether the use of the word entitlement somehow creates an enforceable right, which is inconsistent with the commissioner's policy. Well, if there is a policy, then that admits to the possibility of someone being allowed to sit the exam. And our case was simply that the decision to debar him on the basis that the law precludes him from sitting the exam at all simply wasn't on. So even if the commissioner had the commissioner come to court to say, well, look, I have a policy, this is the policy, and under this policy, you do not satisfy the criteria, and you're therefore I'm not allowing you to sit the exam, then we would have put evidence to meet that case. But that wasn't the case we had to meet. As we've painstakingly taken time to do in our written printed case, we've isolated the relevant parts of the evidence to show that the case that was put to the court was based on a matter of law, that he was precluded as a matter of law, and the law simply did not admit to the possibility of him sitting the exam. Now, my Lord Wilson was correct to take us back to the SFI, because that's where the case is anchored, and the soil in which it was anchored had to do with an interpretation of the regulations not admitting to this possibility, as opposed to there being a policy. Now, that's changed slightly. We are here about a decision that was made over 10 years ago. A decade has elapsed. My client, Mr. Seukeran Singh, is now long retired from the police service. He was, in fact, at the material time, he had 32 years of service, unblemished record of service. He attained a grade 1, which is the most outstanding that you can get in your staff report. He had a grade 1 in his staff report. All of this is in the evidence. And the issue really was that if he had gotten that promotion, you would get a further 5 years in the police service, because there's a differentiation in the age of retirement. But having been allowed to sit the exam under some stressful conditions, you may know that the Court of Appeal convened an emergency session after leave was refused and an interim injunctive relief was refused. I was able to convene the court the following morning, get the interim injunction, and he in fact arrived late for the exam because the exam was starting while we were in the court. But nevertheless, he managed to perform extremely well under those stressful conditions, and eventually, after the entire performance assessment process, placed 5th on the list. So, I mean, the integrity of the facts are on our side in this matter, and I think the Court of Appeal can't be faulted for noticing that in this matter. Now, we say that this is the case when the arguments that have been advanced take us outside the narrow compass of the facts of this case. It's really in the nature of an advisory opinion that is being sought from the board on matters that may consider permutations that do not arise on the facts of the case. And having been recently on the receiving end of the dictum from my lady about not appealing reasoning, but appealing the decisions of courts, we say that the decision in this matter, it's difficult to reconcile the submissions made by my learned friend with the actual decision in this case, where the word entitled does not feature or appear, and further, as noted by my Lord Briggs, the narrow period of 1 month post the performance appraisal report being done on the person, and by mere happenstance, the exam falls also within that 1 month period. Now, I mean, it's really, Mr. Singh was just perhaps unlucky, one would say. But in any event, we say, even if the commissioner had a discretion because there was some unpromulgated policy, which in itself would be rather arbitrary and a rather undesirable way to go about running the police service, we say that once the appellant admits to the possibility of him being considered and allowed to sit that exam, then that's the end of the appeal insofar as the respondent's case goes. Now, if there is such a policy, the regulations provide that official communication from the Commissioner of Police will take the form of departmental orders or standing orders. And you would have seen my learned friend referred you to one such standing order in the evidence earlier about the points system for promotion in the 2nd Division. When the Commissioner was asked to produce this policy, he couldn't. There was an application for specific disclosure of the legal advice that he said his decision was based upon, and he said he couldn't, when that application was made, he said he couldn't produce the advice. And he then switched lanes, as it were, to say he couldn't remember if it was oral or written. But it's a rather unsatisfactory way to conduct a case and leave us guessing as to what really is the main plank of your defense, as it were. Is it policy? Is it statutory interpretation based on legal advice? Or is it a matter of the Commissioner saying, I now have general discretion to manage the police service and I should be allowed to do so without any fetter? Now, what's of interest is the case has changed at every corner. Originally, because they were confronted with the problem posed by Regulation 21.4, which clearly admits to the possibility of promoting someone whilst they're on probation, they sought to invalidate that regulation by saying it was ultra vires. That's Regulation 21.4. They in fact got that from the High Court, and then in the Court of Appeal, you will see when I take you to the transcript, they flip-flopped. And in the Court of Appeal, the Commissioner, recognizing the value of Regulation 21.4, argued that, look, I want to keep this in, and it's intra vires. So that was the flip-flop. Now, if the Regulation 21.4 is intra vires and the Commissioner wants it in, he's got to answer the inescapable question as to how would he, as a matter of practical administration, consider someone for promotion whilst they're on probation. That's the issue. My learned friend says in his printed case, it's for rather exceptional cases. Well, this was an exceptional case. A man with over 3 decades of distinguished, unblemished service, a man who was 5 to 7 days shy of completing his probation period, who had already gotten his staff report and had scored the best possible on the staff report, and this falls within that definition. But whether it's reserved for exceptional cases or not, insofar as it is a possibility, then we've got to answer how would the Commissioner in an exceptional case exercise his discretion under Regulation 21.4. And one has to, therefore, as the Court of Appeal said, think that the sitting of a promotion exam would be facilitative of 21.4. It would give the Commissioner something to go on. It would give him 2 things to go on. A, possibly a staff report. He may not have it because Regulation 21.4 allows them to promote whilst the person is on probation, even before the expiration of the 11-month period that you're supposed to get the staff report. So he may or may not have the performance appraisal report. But if he has the examination result, that would be an objective criterion to which he can have regard when exercising his discretion. So in the Court of Appeal, they took the view that allowing someone to equip themselves, to pre-qualify, to clear the first hurdle in what is a continuum or process by which you would assess someone's competence and capability, that there was nothing objectionable about that. It will, in fact, it was conducive to the good public administration and would assist the commissioner in better exercising his discretion under 21(4) on the basis of some objective evaluation, as would happen by the exam and performance appraisal. What I don't get, quite frankly, is what's the mischief? What is the commissioner concerned about to prevent? What's the maladministration that would arise that is so strong that we should be here today? That's what I don't get. My learned friend answers that by saying, well, someone on probation who hasn't proven themselves would be considered for promotion, and therefore we shouldn't allow them to sit the exam. My answer to that is as follows. The whole purpose of the exam is to clear the first hurdle in a process that is designed to evaluate your competence from different angles. So, if you're on probation and you sit the exam and you top the exam, out of everyone, people who are not on probation, people on probation, you top the exam. Where's the mischief? You go forth, well, if you don't pass the exam, you're out. You have a number 1 exceptional perfect rating on your staff report. Where's the mischief? You then go forward to the interview stage. It's a tiered approach, a piecemeal approach. You then go forward to the interview stage. And if you top the interviews, then where's the mischief? And even if you pass the promotion exam and you got a good staff report, you may perform badly at the interview stage. But the short point is, I don't see, with respect, the merit in the argument that you are still proving your competence and worth as an officer, as a probationer, such that you should not be eligible to sit the exam, or such that you should not be entitled to sit the exam. That's what we're about. It's not eligibility to be considered for promotion. It's eligibility to enter the race by clearing the first hurdle, which really is to sit the promotion exam. Now, my lady, in Trinidad, these things take an awfully long time sometimes. So you'd be surprised. Sometimes the entire process.
You managed to get your injunction remarkably speedy, Mr. Ramlogan. You are to be congratulated.
Well, thank you, my lady. Yeah, I had to. But the reason for that is if we missed that boat, we didn't know when next they'd hold those exams. Oftentimes, the gap between the holding of the exams and the interviews, it's quite long. And it prejudices people's career advancement irreversibly and does irreparable harm. And that's why we had to rush to get that. So, I say firstly, with respect to the argument that there is a policy, we say firstly, there is no documentary evidence to substantiate the existence of a policy. If so, I ask what, pray tell, would be is the criteria in that policy. The commissioner cannot ask the board to give him some wiggle room, as it were, because of some policy that is not put into evidence. The second is that even if there were such a policy, it had to be put as an official document to guide police officers via a standing order or a departmental order, both of which are contemplated by the legislation. I wish to caution that simply because the commissioner is given the power to manage the police service in an efficient and effective manner, it does not mean that it's a blank check. It does not mean that it's carte blanche authority to do as you think and please. That's why it's said that the powers are to be exercised subject to the regulations and the act. And if the regulations are silent on this point, and as noted before, the regulations, when it wanted to create preconditions to allow or disallow someone to sit an exam, it did so in clear and express language. So clearly, the draftsman, if we turn to regulations 16 and 17 on page 951, Regulation 16, an officer of the rank of constable to sergeant may apply on the prescribed form to the commissioner to be allowed to take the qualifying examination for promotion to the next rank. You had to apply on a prescribed form to be allowed to take the exam. That's the kind of language that one would expect to see. My learned friend is asking you to insert this regulation where it doesn't exist and make it applicable to the first division. If they wanted to put such a regulation and make it applicable to the first division, then it ought properly to have been there. And likewise, in Regulation 17, a constable shall not be considered for promotion unless he has 3 years in the service. Well, likewise, if it is that in the first division, an officer is not to be considered for promotion unless he has completed the probationary period, one would have expected to see the equivalent of 17 for the first division. There is no regulation which says that you shall not be considered for promotion unless you've completed 1 year of service or unless you first completed the probation. No such regulation exists. We've got to be careful about supplementing the regulations by administrative discretion, be it at the behest of the commissioner or a court of law. Because these regulations are designed to be a comprehensive and detailed code, as said by Lord McKay of Clashfern in the Raj Kumar and Lala case, which we've cited in our printed case. It's a detailed and comprehensive code. And the reason for that detailed and comprehensive code is because it acts as a procedural safeguard against arbitrariness, against arbitrary exercise of power. The board has been inundated with cases concerning the police service in Trinidad and Tobago from the days of Endell Thomas to Lord Hope's judgment in Cooper and Balbosa and many other cases. And the reason for that is because in our society, the role that the police service plays is so sensitive in the political and social fabric and dynamic of Trinidad and Tobago that the need to insulate it from political or any form of arbitrary interference is one that is at the forefront of the legislature. It can, Lord Diplock's salutary warning about the police service not being converted into a private political army of any government of the day is important. Ultimately, the Commissioner of Police himself is a political appointee. So that's why one has to be guarded about giving through the back door discretionary powers that simply because the regulations may be silent in the face of countervailing regulations that were expressly put there by Parliament through the President to deal with the first division. The first division and the second division are it's clear that there are two different statutory regimes for them. And insofar as there are different statutory regimes for them, one cannot simply copy and paste what is applicable to the second division and transplant it into the first division. When you're at the level of the first division, your competence is proven through the ranks that you've risen. The pyramid structure of the police service means that you're coming to the apex with less officers, less competition for promotion, because there are less officers in the hierarchy of the police service. And maybe that's why the difference in treatment is there, as opposed to someone who is now joining the police service at the lowest rung of the ladder. It's interesting to note how the letter of invitation was phrased. If I could take you to page 59 of the record. Because this also militates against the idea that there's some policy. If there was a policy, one would have thought that the human resource manager of the police service of all persons would know about it. Such that when they came to the commissioner, when she visited the commissioner of police, the first thing she would have said is, listen, here's our policy, we're not allowed to do this. But that's not what she said, and that's not what the letter said. At page 59, the letter of invitation says, pursuant to your eligibility for advancement to the 1st Division, I am to inform you that you're required to attend a written assessment at 10 a.m. in November at the Chaguaramas Convention Center. I mean, we say that that's rather conducive to the idea that he was entitled to write the exam, or he was eligible to write the exam, whichever you prefer. But clearly, the Human Resource Department knew what they were doing. That they resiled from that on the basis of a flawed interpretation of the regulation subsequently is a different matter.
Was this a response to him saying, I wish to be considered for promotion, or was this a letter sent in standard form to every 1st Division officer who was not rendered ineligible by the existence of a relevant...
I think it's a letter, my lord. I think everyone who... seems to be a letter that was sent to everyone, because Mr. Singh did receive a letter in response from the commissioner, which I can find shortly, to his letter. And that would be... We find that at... It's 137, I believe. So, 137. Yeah, you'll find his letter in response at 137.
It's rather weird, though, isn't it? Because it talks about his eligibility for advancement to the 1st Division. He was already in the 1st Division.
Yes, I did.
So it looks as if it's a standard form letter that hasn't been adapted to anything other than the time, date, and place of the exam.
I accept that, my lady. I accept that. At page 137, my lord, the response from the commissioner says, he acknowledges his letter. He said, I'm to further advise that the stipulated probation period alluded to in regulation, unfortunately I can't read mine, is 12 months. When constituted, the period you acted prior to your confirmation did not satisfy the requirements of the probation period. Consequently, you have not qualified for 1st Division assessment. And as such, I cannot accede to your request. Lady, it seems that the error repeats itself, but this is not a generic letter, because he speaks about not qualified for 1st Division assessment, but he was already in the 1st Division.
I think it's referring to Regulation 21 under the stamp.
I see.
Looks like it.
It could be. Yeah.
Looks like it.
Sorry, my lady. But the point is, what we were told is nothing about a policy, but rather a reference to the regulation. At page 126, we'll see the relevant evidence of what transpired. And at 126, paragraph 7, we're told that Ms. Veronica Simon, who is the head of Human Resources, said the claimant was not eligible to sit the written assessment. He satisfied himself he was not so eligible. He was also satisfied about other officers. I arranged a meeting with these other officers and advised them that they were not eligible because of their failure to satisfy the requirement of the 12-month probationary period. The claimant would have in fact completed 11 months and 24 days, 11 months and 24 days, and I sought legal advice on this requirement and based my decision on same. All officers who fell short of the 12-month probationary period were denied the opportunity to sit the exam. So that's the evidence, but there's nothing there about a policy. There's nothing there about a policy. So we feel it's a little odd that would arise now. Now, if the regulations are silent on equivalent regulations like 16 and 17 for the second division, then unless there is a regulation prohibiting a probationer in the first division from sitting the exam, we say he should be allowed to sit it. The 60 points on the staff report, I mean, I have to confess, I had some misgivings in the Court of Appeal about whether that is a precondition to allow a probationer to sit the exam. And if so, which staff report do you refer to? Yeah. My Lady Arden had raised the relevant regulations, and we've had copies of it made. Sorry, my Lady Black, sorry, beg your pardon. Awesome. I apologize, sorry. I apologize, my lady.
Thank you.
And we'll see a performance appraisal report shall be in such form prescribed by the Commissioner, may be made in respect of each officer, whether he holds a permanent or temporary or acting appointment or is employed for a specified period. I think that's the answer to my Lord Briggs' question about whether it necessarily has to cover a 12-month period or it can be for a partial period. And the answer is yes, it can be for a partial period. Provide communication to the officer about the nature of his job, his career potential, ensure the officer's participation in established standards as required by his job performance and career potential. A three-way total shall relate to the period of service during the immediately preceding 12 months. But look,
this is all to do with eligibility for increments.
well,
If you look at 73.1 and then back to
and
71.2a.
Yeah, so although I think 71 2b says that you're getting it once a year anyway.
yeah.
Yeah.
So it seems to be, if you're coming up for an increment, they jolly well want to see your performance appraisal to make sure you're worth the increment, but you're going to get an annual one anyway.
Yeah.
That's what it looks like.
Yeah. The important thing, however, is that sometimes it's broken up. And the reason for that is you can have an acting appointment. So if I'm acting, if I'm a constable, for example, and I'm acting as a corporal, the person who would be my superior, who supervises me, obviously will have to be a police sergeant. So they would have to do a bit of my staff report for the period of time that I was acting as a corporal. When the acting appointment comes to an end and I revert to being a constable, then the person who's supervising me for that time would have to do one for that period of time. So it's not, in reality, I think that's why 71(1)b is important. And I say all of this to make the point, my lady, that the staff report that you need the 60 points on, it need not be the staff report that we're thinking about in the 11th month. It could be the staff report, for example, in your substantive rank immediately preceding. It may be the only available staff report to go on. I don't think that in the absence of a clear and express provision to deprive someone of the opportunity to sit that promotion exam as the first hurdle to be cleared in the promotion process, that we should necessarily say that an officer is disentitled or somehow debarred because he doesn't have that particular staff report.
So is your submission that the performance appraisal report in Regulation 19.3 is the latest one for that officer in whatever role?
That's correct, Minister. That's correct.
The latest one?
Yes. And I say that also because we have had perennial problems with the performance of, with the preparation of staff reports, and sometimes there's a delay. Can I just take the court through the Court of Appeal, what transpired in the Court of Appeal, as I consider it to be of importance. And if I can pick it up at page 779 of Volume 2.
I'm so sorry, I missed your page number.
779.
Thank you.
You will see from line 30, Justice Biljamada, let's take it back a bit. The Commissioner created initially his policy based on legal advice and confirmed it when he got the query. Is that what you're saying? I believe the Commissioner created the policy based on interpretation of the regulations and the Act. That's his legal interpretation. Yes, please, my Lord. Fair enough. Here's the question. If, as a question of law, both the Commissioner's interpretation and his, whether prior to or subsequent to, but certainly subsequent to the legal advice he received about it, which appears to have been oral, are wrong in law, what does that do to the policy? If it is wrong in law, then the policy cannot be maintained. So that's the first hint.
This is counsel for the Commissioner.
That's correct, please.
Yeah.
And then we see that repeated at page 780 overleaf at line 26. It matters not in a sense who gave it or whether the judge. What I'm trying to get at is if the interpretation of the Act and the regulation by the Commissioner was the basis of the policy and that turns out to be flawed, does it not undermine the policy? Yes, my Lord. On page 781, line 18, you have agreed that if the legal underpinning for the policy was flawed, then the policy goes. Yes, please, my Lord. And then we go to page 783. And we see at line 28, Justice Biljamada says, the one thing is certain is that the Act does not say you shall serve the 12 months. That means you shall serve the 12 months before being allowed to sit the exam. That is true. All the Act says is that you must serve the prescribed period. Yes, please, my Lord. So the question in this case is whether, when the judge said that the regulation is ultra vires the Act, in a way that statement is flawed. Do you agree? Yes, I do. That's the concession. In respect.
That's Regulation 21.4, isn't it?
That's correct, my lady. And they had argued in the High Court strenuously and persuaded the judge that it was ultra vires, because that was the only way they could have gotten around its clear implication that you can promote someone whilst they're on probation. And then we go to page 789. At line 27, Justice Biljamada. So therefore, you're not arguing that 21.4 is ultra vires the Act, in fact. You want it in. Counsel for the Commissioner. It would assist the Commissioner, my Lord. We want it in, yes, please, my Lord. That's not quite what you argued before the trial judge. I understand, my Lord. Alternative argument. So,
It wouldn't be the first time that they changed their stance between first instance and Court of Appeal.
no, it wouldn't be, lady. Save and except that they got essentially got a declaration invalidating that regulation in the High Court. It wasn't a matter of mere submission. It was a matter of the court itself invalidating the regulation. So it had, it has a little more bite than, withdrawing a concession, as it were. But the point is, why would the Commissioner want Regulation 21.4? That's the issue. Why would he want it? Why would he argue now to preserve a regulation that would give him the power to promote someone whilst they're on probation? Why? It's because there's an implicit recognition that he appreciates the value of being able to promote someone who may be an outstanding officer, notwithstanding the fact that they're still on probation. And that is a ballistic missile that nullifies, with respect, my learned friend's argument, that, well, look, you haven't proven yourself as yet. You're still on probation. If I take you to page 790, at line 25, at line 21, sorry, what the regime is doing is, it is really what it says, keeping the merit in. So if in terms of merit you achieve standards, the performance standards and the performance appraisal and the exam, then you are saying the Commissioner has a discretion under 21.4 to promote even if the probationary period has not passed. Yes, my Lord. If you are right in that, don't you see where it leads to? That a person may be entitled to sit the promotion assessment exam prior to 12 months? Yes, my Lord. Because otherwise the Commissioner would never be able to exercise his discretion under 21.4, because 21.4 does not remove the pre-qualifying prerequisites of performance assessment and examination. It does not create an entitlement. That's their position. That's where the entitlement problem arises. Now, and then we go to the page overleaf at 791 at line 17. I accept completely, 16, I accept completely that it does not give an entitlement to be promoted. Where you and I are parting company in the logic is for the Commissioner to exercise a discretion under 21.4, somebody or bodies must meet the merit, pre-qualifying prerequisites, one of which is the exam. So actually, for the Commissioner to exercise his discretion under 21.4, or should she wait, or should she want people to be doing the exam within the 12 months? I agree that's a possibility that may happen. And then, at page 794, at line 23, Justice Pijama says, so the first place we need to go to ask is what is the legal framework within which this must be understood? Your first premise. And if one of the premises is that a person may be considered for promotion within the 12-month probationary period, then it is more consistent with that people be permitted to pre-qualify, that is to say, then it is more legitimate that this is done than to say you may be considered for promotion between 12 months, but you can't qualify until after. The short point is all you'll be doing is pre-qualifying yourself so that you'll be eligible to be considered for promotion. And what the Court of Appeal said is, look, it's more facilitative and supportive of the power given in Regulation 21.4 that someone can sit the exam, or else the Commissioner might be exercising his discretion under 21.4 to promote a probationer in a vacuum. And how much better, how much more conducive would it be to good public administration to at least give him some information that might be relevant to the exercise of that statutory discretion. And at page 803, line 19, they discussed regulation 16 and 17, which applies to the second division. And then at line 20 on page 803, Justice Bijam. Now, where is the equivalent? Ms. Batiste, there is no particular equivalent for the first division. So therefore, if the law thought it necessary to be so particular about constables, if its intention was consistent with that, it could have repeated that framework in relation to, say, first division officers. At page 807, line 11, we agree that there is nothing that says that that cannot be done as per 22, within the 12-month period or even before. Yes, it is possible. I'm not saying that it is not possible. It is possible. It is not excluded by the regulations. It is not excluded by the regulations, but it cannot go past 12 months. I mean, the discussion is whether or not you can get promoted within the 12-month period, and she's conceded, counsel for the commissioner, co-counsel for the commissioner conceded that that could be done. If I take you next to...
Can I just ask a factual question?
Yes, please.
The performance appraisal report within Regulation 19.3 on which Mr. Singh relied was from which period and which post of...
Oh, no, that was during the period of probation. It was in the 11th month of his period of probation. So the speculative issue doesn't arise as to whether it should be that staff report or the other. But I mentioned that because if one narrows it down in the way my Lord Briggs has, I mean, it does seem to me to be an absurdity with respect that, look, 21.4 is only exercisable if a man gets his performance appraisal report on time on the stroke of midnight when he completes his 11th month, B, that he sits the qualifying promotion exam so soon after, and more importantly, gets the results within that 12th month, and that he gets interviewed or that the commissioner considers him without the interview for promotion, as the case may be. And I don't think that the power given to the commissioner is meant to be exercised in that way. And I say that because the police service is in a state of fluctuating transformation. In the old days, people had to have 3 O-levels to enter the police service. And we've come a long way since then. Now we have so many graduates and so on that are actually considering a career in the police service, and there's a tension, an unhealthy or healthy tension in maintaining the balance between seniority, qualifications, and merit and ability. And that's why we've introduced these revisions to the promotion process, to try and get at something other than seniority to get the cream to rise at the top. And that's why the commissioner wants to keep that power. It's because you may have a bright young assistant superintendent who has an LLB degree, as they now do in the police service, or who is a qualified attorney at law. And you may want to put that person through the rigors of completing the probation period to go and write, basic English and other exams and so on, when he's of stellar quality. And if you don't promote him so that he can get a decent salary in the next rank, he's going to go in private practice. And instead of prosecuting on behalf of the commissioner, he'll be defending against those who are prosecuting. And that's the framework, the social framework in which we must locate Regulation 21.4. He argued in the Court of Appeal to retain that because it is of value. I agree it's of value. But the problem is we need to free him of what amounts to the illegal imposition of a self-imposed fetter on the exercise of his jurisdiction. It's a self-imposed fetter, because he's fettering his discretion under 21.4, self-imposed, by saying the man has to first complete the probation period before he can sit the exam.
And could I just ask, do we have the date of the performance appraisal report that was relied upon?
I'm not sure we have the exact date, but we do know that it was, we do know for a fact that the performance appraisal was done, because we are told this, what page is it on? it's in the judgment, but it's also in the evidence in a letter. We'll get the relevant... whilst we're looking for that, we'll come back to it, but I know it's in the judgment and it's... You can find it at 133. At 133, record volume 1. And you'll see at page 133, he says that in accordance with Regulation 22, my performance appraisal was prepared and forwarded to you 1 month before the probation period expires, which is November 29, 2008. And in his evidence, he subsequently said that he had gotten a grade 1, which is, you will see that reflected in the Court of Appeal's judgment. But
the printing isn't very clear, but I think mine says, my performance appraisal can be prepared and forwarded to you. In other words, I think he's making a sort of analytical construction point.
Well, my Lord, can I just take it to page 409 instead then?
497?
409, my Lord. Paragraph 6, page 409.
Yeah.
And he says, as to paragraph 9 of Mr. Filbert's affidavit, I say that the departmental order referred to is not merely to show that I wrote the assessment exam. In addition to this, the promotion assessment process entails an oral exam in which I was successful. Furthermore, my performance appraisal gave me a grade 1. All of these factors entitled me to be placed on the order of merit list, which was published in so-and-so.
But I mean, that doesn't actually say which performance appraisal report, because presumably he'd had earlier ones. So the date of the letter at page 133, assuming the word can is there, as my Lord Briggs says, he didn't yet have that one, but had some earlier one.
Look, this arose during the course of the hearing in the Court of Appeal, and because that was the assertion, and the Commissioner did not seek to contradict it, the position taken by the Court of Appeal, and quite rightly, was that the performance appraisal would be assumed to be that set out in the evidence of the respondent. And you will see that at page 880, paragraph 23. It's the supplemental with the judgment from the Court of Appeal.
Yes, thank you.
Paragraph 23. In addressing the issue as to whether the appellant attained the minimum 60 marks on his performance appraisal report, it's noteworthy that Regulation 22 provides that in case an officer is serving a 12-month probation period, the senior officer in charge is required to furnish the Commissioner with this report before 1 month before the probation period expires. Thus, by 18th November, the appellant having begun acting as superintendent on the 19th of November, the Commissioner ought to have been aware of the marks attained by the appellant. 16.3 requires the Commissioner send the points to the person conducting the promotion assessment prior to its commencement, and in the instant case, it's clear that the Commissioner invited him to sit the exam. There has been no challenge to the appellant's evidence that he attained a grade 1 in his performance appraisal, and it is therefore common ground that he did well enough to be placed 5th on the order of merit list on the 9th of January. So, we proceeded on the basis that this was the staff report prepared at the end of the 11th month in his period of probation, and that was what the grade 1 graded.
Yes, thank you.
My lords, my lady, in practice, although I'm going beyond to consider the speculative questions we are engaged upon, but in practice, there is If the regulations are silent on who is entitled to sit the exam, why is it not, as a matter of practical administration, why is it not good for the police service to simply allow persons who are in the immediate rank below, whose next career move would logically be to the rank above them, to sit the promotion exam in the first division?
But you're speaking in terms of allow, and that raises the whole question because, first of all, not ineligible,
Yes.
but why is it confined to the rank immediately below? Why isn't it anybody who wants to take the exam?
Because, for two reasons. I think the regulations do qualify that promotion to the first division, and within the first division, you'd have to be a member either of the first division or aspiring to enter the first division. But more importantly, I think the question was posed earlier as to whether you can skip ranks. And that's the crucial question. In my experience, they don't allow you to skip ranks in the police service. You've got to climb you've got to spend some time in each rung of the ladder.
That's not in the regulations or the
It isn't
other
valid.
provisions.
No,
so it
isn't.
must be an unwritten policy or a written policy?
It might be a policy practice. Perhaps my learned friend might be better placed. But all I can say, my lady, is that I've not seen it done. I've done quite a few cases on police service promotions, and I've not seen it done where they've allowed people to skip ranks. So that's why I say, in the immediate rank below may very well be one option that is open to the commissioner. And I say that simply because at the end of the day, what you really want is, you want a culture of meritocracy. You want the best people to go forward. And if the promotion process is designed to evaluate people on merit and ability, then why do we take a restrictive approach towards allowing them to enter the race to see whether they can clear the first hurdle? Bearing in mind, the only thing I saw that, like a train coming to hit me with this argument was, suppose there's an undesirable person, and he manages to, be competent but undesirable. And the answer to that is that the regulation framers thought about that, and they gave the commissioner a power of veto. And you'll see that in regulation. You will see that in regulation.
Yeah.
It's in section 17.
17. I'm grateful, my lady.
Certainly that refers to the first division. On page 938. Police officer will not be appointed to an office in the first division if the commissioner objects.
I'm deeply obliged, my lady. Thank you. Yes. So he has a power of veto. So there are inbuilt safety mechanisms. So rather than adopt a restrictive approach to people entering the race to demonstrate and prove their competence in competition with their colleagues, why not leave it open so that people can enter the race? And it's either you might give birth to the race might give birth to Usain Bolt or not. But the short point is, I don't see, as a matter of policy that is conducive to good public administration and what is in support of a culture of meritocracy, that taking a restrictive approach in the absence of clear regulations to the contrary makes as a matter of good public administration any sense.
Might it be said that section 17A3, to which we've just had our attention drawn, which gives the commissioner a power of veto, rather undercuts your argument that the regulation 19 must be treated as a complete code in order to preclude arbitrary decision-making on the part of the commissioner?
Well, no, it doesn't, with all due respect. What it does is it means that the commissioner cannot prevent people from entering the promotion assessment process. Those persons they must be allowed without restrictions by the commissioner, unless the regulations so provide, to enter that race, clear each hurdle, when they've completed the race, the commissioner is given a specific power of veto, and he can deny them the right to mount the podium to receive their trophy. Now, that, of course, will in itself be subject to judicial review and the constitutional right to equality of treatment. It cannot be a power of veto that can be exercised in bad faith.
And it can't be exercised before the officer appears with a ranking on the published order of merit.
That's correct. Yes.
And is that, when it said published, is that fully published so anybody in the country can see it?
No, it's published within the police service.
Oh.
And it's not for public disclosure.
I was going to ask, thank you.
Yes, I'm obliged.
So it's only an internal publication?
Yes.
You say it's subject to judicial review.
Yes.
I was wondering about the Police Service Commission's power to hear and determine appeals from the decisions of the Commissioner
Yes.
with regard to promotion.
That would be an alternative remedy. I had in mind the board's decision in the case of Firoza Ramjan and Ganga Prasad Kisoon, where there's a similar provision for a prime ministerial veto over senior level public servants. And the board said that the power was amenable to judicial review. And it's a similar constitutional veto that was exercised. And you've got to act fairly, and you've got to act rationally, and it can't be exercised in bad faith.
I'm just wondering about alternative remedy.
But you're smack on, my lady, I accept that. There would possibly exist an alternative remedy, but it may not preclude someone from pursuing a matter under the Constitution, which remains the supreme law and guiding light, if your right to equality of treatment is breached. If, for example, you can show that you were a victim of discrimination. My lords, my lady, unless there's anything further, I think those are the submissions for the respondent. I'm obliged.
Thank you very much, Mr. Ramlogan. Thank you. Yes, Mr. Rowe.
Lady, very briefly, I'm very grateful to my learned friends for drawing the board's attention to Regulation 71 and the discussion to which that gave rise, I think in answer to some questions from Lord Sales, and what was accepted, I think, by learned friends, shows that the practical objection, that the practical point that Lord Briggs made in the course of my opening may not, in fact, have the force, as I'm sure the board will have picked up, that it might initially have been thought to have, because the point you'll recall was, well, hang on, this can only apply anyway, the argument we're having can only apply anyway to people who are in a position to qualify for the examination in the sense that they've got their performance appraisal report, and since that has to be sent within by the end of the 11th month of their probationary period, we're talking about a fairly small class of people. 11 months on, they've got their performance appraisal report. Now they're, even though they're probationers, wanting to sit the examination for further promotion. But if it's right, and on the face of it, it would seem to be right, that actually one can use, in qualifying for the purposes of Regulation 19.3, for being a qualifying person within 19.3, one can use any performance appraisal report, the most recent one, then that practical objection falls away, because in fact we are concerned with anybody who is a probationer who has in his or her possession a performance appraisal report showing 60 points or more, and who will then want to apply to sit the examination. So that the practical objection there falls away.
Could I just ask one point, just so that I can understand it? On Regulation 71(2)A, talks about in respect of each officer who is within the scale of pay, you get the appraisal before an increment. Can you help us with how that works? If you go into the police service, are most positions or some positions on a spine point or something like that, and you go up?
I'm afraid, my lord, I'm not really in a position to add anything to the text of the regulations.
All right.
I'm sorry. But one imagines that it's operated in a system in a way like that, but I can't really add to Bishop's speculation as to how it ought to work. Milady,
Well, it sounds as if there's a scale of pay for each rank.
Yes.
Which has a maximum, so that A
that's right, you get to the
is
maximum.
dealing with somebody who's not yet got to the maximum, and B is dealing with somebody who has.
Yes. Either way, the effect of it is that there is an obligation under the regulations for there to be regular performance appraisal reports.
Yes. In fact, sorry, I was just interested in the timing. You know, do you go up each year, in which case you're getting a report each year, or is it 2 years, in which case you're getting them every 2 years? But if you can't help, don't worry.
Yes, I see what your lordship means, and one would expect, presumably, that there is some regularity in the increments. But either way, once it's accepted that the qualification that you have to have in order to put yourself forward as a qualifying officer under Regulation 19.3 doesn't have to relate to something which is produced because you're a probationer, under the provision for that to be done by the 11th month of your probation. Once that's accepted, then it must follow that potentially the class of people who can say, I'm a probationer, I've got 60 points, but I would like to be considered for further promotion, even though I'm still a probationer, is actually much bigger. It doesn't just cover people in the last month of their probation. My lady, the only other submission I'd want to make is this. One couldn't help but notice that having started off by saying that the Commissioner's appeal should be dismissed on the short ground that the Commissioner, made an error of law by stating that Mr. Singh was ineligible, and indeed having essentially accused the Commissioner of seeking an advisory opinion on this question of entitlement. My learned friend then spent quite a lot of his speech, in fact, seeking to uphold the Court of Appeal's determination about, or Court of Appeal's assertion about the existence of an entitlement on the part of probationers to sit the qualifying examination on broad policy grounds. And in the course of that argument, my learned friend asks, perhaps rhetorically, where is the mischief in the Court of Appeal's reasoning about entitlement to sit the examination? And my learned friend urges upon the board, well, no harm is caused if police officers are given a right at least to sit the assessment. My lady, the answer is this. The mischief is this. Simply, the courts should not, in my respectful submission, be in the business, absent some cogent reason for them to do it in a particular case, of asserting that police officers have particular rights against the Commissioner. The Commissioner, like police commissioners, no doubt the world over, has quite enough on his plate, one expects, without the court essentially getting involved in the management of the personnel aspect of the police service. And that is essentially what the Court of Appeal did. And it had no good ground for doing so. And in my respectful submission, the board ought not to repeat the error. My lady, those are my submissions in reply, unless you have anything further for me.
Thank you very much indeed. Well, your prediction has been more than justified. Thank you both very much indeed for your submissions in this interesting case. And we shall now take time to consider our judgment. We'll now adjourn.